In International Harvester versus Ruckelshaus, we'll see whether the Environmental Protection Agency had the burden to disprove car manufacturers' claims that new emission technologies weren't available. In 1970, Congress amended the Clean Air Act and set new standards to reduce emissions in 1975 models of light-duty vehicles. Congress's emission standards were drastic and were designed to force vehicle manufacturers to create state-of-the-art emission solutions. Because there was a concern that manufacturers might not be able to meet the new standards by 1975, Congress provided an escape hatch that would allow manufacturers to request a one-year suspension of the new standards. EPA Administrator William Ruckelshaus was only authorized to grant the suspension if certain conditions were met, such as if the control technologies needed to reduce the emissions weren't available and the National Academy of Sciences, or NAS, confirmed that the technology wasn't available. In 1972, multiple vehicle manufacturers, including International Harvester, requested a one-year suspension. The manufacturers submitted data that showed that only one vehicle out of 384 test vehicles could meet the 1975 standards. None of the manufacturers' vehicles were able to meet the emission standards after being driven for the required useful life of 50,000 miles. The NAS confirmed the manufacturers' findings and issued its own findings that the technology needed to meet the new emission standards wasn't available. Ruckelshaus made adjustments to some of the manufacturers' data. For example, Ruckelshaus made assumptions that the gas in 1975 would contain less lead, which would help reduce emissions. After making numerous adjustments to the data, Ruckelshaus concluded that the manufacturers failed to show that the requisite technology wasn't available. The car manufacturers petitioned the United States Court of Appeals for the District of Columbia Circuit to review Ruckelshaus's decision to deny the suspension.